property over that particular brand.
Attorney, before we go on, because I was listening to the news that you put on right before in the traffic report, I'd just like to mimic. Ladies and gentlemen, the traffic report. We have traffic. Hindi naman naiiba. And now for the weather. Ladies and gentlemen, it is hot or it's wet. Ganun lang naman sa Pilipinas. But yes, going back to that, I have a question for you, Attorney. No? Why can't we make it mandatory? Is it not fair for the businessman? Don't we secure the entrepreneurs, the professionals that register, so much so that should they go to the SEC and or trade in industry to register, why can't we compel them to protect them? Not because the fees are nominal.
Yes.
Papasok ka naman ng negosyo. Papasok ka ng negosyo, I mean, you're not gonna come in with 5,000, 3,000. Kung sari-sari store operator ka or you're a small fly-by-night, whatever, chances are you won't even register. Maglalagay ka na lang sa police, the corner police, kung ano-ano, or patago-tago, or you won't even, hindi ka lalagay ng karatula. But for those who are serious, dead set, and they put their money where their mouth is, so to speak, meaning they make some real investments. They rent a place and or use their place if they own it, and they make real investments either through their inventory buildup and their product manufacturing. When they do that, why can't we compel them, not because of fees, but to protect them in advance so that they may be aware in the event when they do become successful, at least protektado na sila? Why do we allow the trademarks to be like we don't compel them? Why do we do that? Sana etyo derecho na lang, magkano lang naman yan. Ang trade name 300. Magkano yung SEC? If I'm not mistaken, you're given 60 days after you register online. Depende na yan sa paid up capital, di ba, sa investment mo. But in this case, pagdating sa IP, intellectual property, sana isabay na lang. Ano ba naman yun? An extra 1,000 pero safe ka naman. Magkano ang clearances of local government? From garbage to whatever, to building permit, occupancy permit, ang dami. But those permits, every time I try to fight them, I remember because I've been an entrepreneur for close to 28 years, basically are there as what we call regulation to protect the entrepreneur. That's what local government will tell you. I mean, after all, when they say engineering permit or building permit, it's to secure that your location is in order, na hindi bumagsakin, hindi gumuho. Food and drug or whatever, the garbage, to make sure your place at least is secured from infestation, di ba? Animal or rodent infestation, and so on and so forth. Why can't we do that? Like TPL, third-party liability, di ba? When you register your car.
It's mandatory.
Oh, mandatory na eh. In the old days, I remember yung bata ako, wala pang ganun eh. Why can't we make it mandatory? Is that not possible?
Well, we need to have enabling law. First of all, because
but isn't that why we have Congress? Di ba bigyan natin silang trabaho?
Definitely, you're suggesting that we make trademark registration mandatory for all business owners' protection, because otherwise you really cannot go after those who are copying your brand unless you're registered. Because you don't own the brand if you're not registered. It's the only way to own it.
In other words, become proactive and compel them for their own good. Kasi tama nga naman, sasabihin ng sa dulo, after 5 years, hindi mo pala, you don't own this brand, may gumaya. All you gotta do is watch a businessman who's remiss with IP, watch his success, duplicate his trade name, register it in advance, and then keep quiet. Let him build a name. And when you're ready, let's say 4 or 5 years later, he's built the brand, then you put up a store right beside him and you put the name, and then you sue him for using your trade name. He has to change his name. Pero katabi ka, you get all that goodwill into your store, which can happen.
Which is the essence of copying of many business owners. In fact, and this is a settled case with the Supreme Court. We were talking about first to file system in the country, and that's what our legal system is when it comes to trademark registration. If you're all familiar with Shangri-La restaurant in Quezon City, it was the first one to register the trademark Shangri-La ahead of the hotel.
Ahead of the hotel.
Yeah. So when the hotel started operating here, they sued for trademark infringement of that restaurant against that restaurant, but the restaurant won in the lower court. saying the court said the court was in the right. You see, the restaurant has the registration here in the Philippines, and the hotel doesn't have it. So the court ruled there's registration, the trademark is owned by the restaurant. However, when the hotel, of course, appealed the case and it went on to the Supreme Court before it got reversed in favor of the hotel, saying that the hotel is internationally well known, the trademark is internationally well known, so the registration was in bad faith on part of the restaurant. So that was how the Supreme Court ruled, settled this first two. I mean, this is an example of a glitch of a first to file system.
May question of attorney, no? Pag sinabi mo first to file dito sa Pilipinas, does the trademark registration, is it, once I register here, okay na rin yan sa Hong Kong? O dito lang sa Pilipinas lang yan?
Trademark registration is territorial.
Territorial,
all over the
that's the word.
Nations have to legislate per country. First of all, they have to provide for trademark registration per country, and you cannot enforce your trademark registration in the States unless you claim that you first registered here. I mean, you have an earlier filing date.
Can't we say on that condition that the Supreme Court erred in that specific case with Shangri-La? Because it's territorial, the restaurant should have kept the name. And the big name, which is, because Shangri-La really is only an Asian hotel chain anyway. It's not necessarily worldwide, it's Asian.
Like any other general rules, there are exceptions. And the exception to the first to file system of trademark registration is international well-knownness.
Because that's happened to us in super brands. Alam mo, in the Philippines, there are so many award-giving bodies in the Philippines, but they're all created in the Philippines for the Philippines. You know, you have the best barbershop, best this, best that, best whatever, trusted brands, but they're all created here. They have no real international presence. If I'm not mistaken, the only ones is, other than super brands, is the SGS or the ISO. Other than that, everything is basically local. So when they do that and they copy you, in this case, I guess if I can prove prominence worldwide, then if somebody does copy, and they did try to do it in the Philippines, believe me, buti na lang they backed out. But need I go through the whole judiciary process? Because that's very tedious and expensive. Biro mo, you start with the regional trial court, the appellate court, and then the Supreme Court. And alam mo naman sa Pilipinas,
10 years for a case to get decided.
Gee, 10 years? That's quick. Look at the web case. Celebrity na yun, may pera na yun. It took them 20 years, regardless of the merits of the case. I'm not going to go into the content of the merits of that case, but still 20 years. In our country, the judiciary, in the legal system, really, it takes 100 years. I think we wait for the complainants to die and pass on before we make a ruling. So at that point, maybe the courts, wala na silang guilt kasi patay na yung mga respondents. I'm being sarcastic. I'm being sarcastic.
Well, the Intellectual Property Office of the Philippines, or IPOPHIL, has quasi-judicial functions, and there are within the IPO mediation and arbitration efforts or alternatives to dispute
So in your
resolution.
offices, it can stop there. The buck can stop there
The buck can
already.
stop there.
Hindi na
The
kailangan
thing
to
is,
go.
we have to promote it in order for people to be more aware that there is such a system that they can use. There is such an alternative.
Why is there an awareness problem with IP? I don't understand that when it's such a big requirement and it's a significant, it plays a very significant role in trade and commerce. Why is IP so unknown to many?
Well, definitely it's starting to gain ground. It's starting to become relevant to many after they realize they're being copied left and right, especially those who have built on goodwill. However, I will not put the blame on just one side. I'll put it both ways. It's also consumers also have to seek out protection for themselves, because, as I've said, it's not mandatory. It's not a human right that once you create this intellectual property, it's yours and the state will enforce it on your behalf. No. You have to look out. You have to be your own lookout when it comes to property.
But shouldn't that be the mandate of trade and industry, the department, not necessarily the registration of the trade name? You know, it's like the standardization law. The consumer protection and regulation is by the DTI, Department of Trade and Industry. Maybe it should be their responsibility and their issue to actually bring this up. for legislation to make sure, di ba? I mean, after all, they're there not to just get a salary. They're there to protect us consumers and, even more important, the entrepreneurs.
We will discuss that question further after a news break from BBC News. Welcome back to Piracy Watch with me, Attorney Sarah Jane Sugitan. Joining us this morning is Mr. Harry Tambuatco of Superbrands. Now, before we get back to our discussion on trademark registration, allow us to give you updates from the Intellectual Property Office of the Philippines, or IPOPHIL. IPOPHIL reported that as of December 2010, 5 billion pesos worth of pirated products have been confiscated altogether by authorities. According to Attorney Ricardo R. Blancaflor, Director General of IPOPHIL, there is a need to grant enforcement powers or police powers to IPOPHIL, which remains mainly a policy-making body. House Bill number 3417 and Senate Bill number 2553, now pending, seek to empower IPOPHIL to undertake enforcement functions and visitorial powers. Such powers will include the duty to search warehouses and seize infringing commodities. Going back to what we're talking about, Mr. Harry Tambuatco here from Superbrands, how do you think businessmen should address the lack of awareness? I mean, aside from the government taking efforts, of course, the IPOPHIL taking efforts to lobby for enforcement powers and reach out to stakeholders in order to protect them from unfair competition and copying, should the businessmen also reach out and somehow, look after their own back?
Well, we are dependent on the Intellectual Property Office to reach out to us to generate that awareness. Apparently, the Department of Trade and Industry is not very proactive in explaining to us or generating this awareness that should protect us. I hate to say it, but I pass the buck on government in this case, most specifically DTI. Sila dapat ang nag-ano sa amin, nagbibiso, nag-aabiso. Kanyari ako, Ilocos ako, all the way in Batanes. Magtatayo ako ng barber shop, yung ganun ba. Sayang naman, after 10, 20 years, in the old days before the onslaught of Shoe Mart and Robinsons and the big malls, they were basically the mom-and-pop grocery stores. Like Evelyn, Jones, and whatever, di ba? Yung mga sari-sari. Hindi, pero malaki na, mga maliliit na grocery yan. I remember I used to go to many groceries and there were mom-and-pop operations. But they did the trick. They supplied food and other, they expanded to office supplies and other things. The local grocery store. Ang nakakainis dyan, those that created their names over the years, nawala. No?
It's called free trade.
Yes, I know it's free trade.
And I'm being sarcastic.
If we knew then, and then these entrepreneurs knew that how we could protect our trade names, they may have been able to stay the business, di ba? Of course, it's a bad example because yung sa groceries, SM talaga is phenomenal, the SM expansion and the mall expansion. But for example, barbershops or bookstores or even butika. Ngayon, at least may mga lumalabas na butika like Generica, Generic, very close, no? Iba-iba mga pangalan nila. South Star, other than Mercury, the big boys, no? When they create their names and they stay the business, imagine kung nawawala, tapos sasabihin ng iba, tatawagan ka pa rin, hindi yung pangalan na yan, kailangan sara mo yung karatula mo, ibahin mo. I mean, nakakainis eh. So, again, I go back to you, attorney, and the IPO office, more of the DTI, because if I'm not mistaken, that's the mandate. That's why we trade and we do commerce under what we call government regulation. So it's up to regulation and or the bodies that are, or the powers that are, to advise us naman. Diba?
Yes, definitely. And the thing with those who complain to us, the stakeholders, the business name owners, the trademark owners, and invention owners, they come to us and we tell them that we don't have police powers. See, that's the problem, and that's what we are lobbying for in Congress and in the Senate, that we ourselves be granted enforcement powers. There'll be a task force headed by IPOPHIL that, of course, will not only search and seize commodities, infringing commodities, but also be the ones to start negotiating and, like, for example, the IPOPHIL recently held negotiations with the Green Hills Shopping Management Center, and as of last month, there are no more fake Louis Vuittons. I've heard.
Hindi na ako pwede bumili ng LB doon.
In Green Hills, because the Green Hills Shopping Management Center has committed that it will now police its own premises. Meaning that it will enforce the provision in the lease contract that the lessee cannot sell